Hello everyone. In this time, I have decided to contribute in your preparation for the Advocate on Record examination. So as we don't have much time, we will be covering some very important topic, and first subject which I'm going to take is the practice and procedure. We must understand that practice and procedure is divided in two parts. First, you have to read the Supreme Court rules. In the coming part of my videos, I will be telling you that what are the important rules which you may cover. Second is the aspect of union judiciary which is provided under chapter 4 of part 5 of the Indian Constitution, which will start from article 124 of the Constitution and go to the extent of article 147 of the Constitution, though we will be covering most important articles in that. So first we will be starting today with article 124 of the Constitution of India. So if we read article 124, clause 1 provides the strength of the Supreme Court. As we see that today the strength of the Supreme Court is 34. But how it has come? So if you read article 124 clause 1, it provides that there shall be a Supreme Court of India consisting of a Chief Justice of India, and until a Parliament by law prescribes a large number, this is very important expression, of not more than 7 other judges. So when the Constitution was adopted, the number of judges were 8, 7 judges and 1 Chief Justice of India. After that, Parliament, as you have studied in article 124 clause 1, that Parliament by law prescribes a larger number. So Parliament in its own wisdom in 1956 came up with one act, and it is called the Supreme Court Number of Judges Act in 1956, which was consisting of 2 sections. And in 1956, the strength of the Supreme Court first time increased to 11 judges from 8 judges. And then second time it was increased in 1960 to 14 judges, then to 18 judges in 1978, then to 26 judges in 1986, then 31 judges in 2009, and then 34 judges in 2019. And the last amendment was Supreme Court Number of Judges Amendment Act 2019. So from 2019 till today, the strength of the Supreme Court has not increased. So we have 34 judges. Sometimes there's a confusion that whether these 34 judges is excluding CJI or including CJI. So please remember, this 34 judges includes the Chief Justice of India. So today the strength of the Supreme Court is 33 judges plus Chief Justice of India, so making it total to 34 judges of the Supreme Court of India. Now the second topic, which is very important, which we are going to cover, is the appointment procedure of the judges of the Supreme Court and also of the High Court. So if you read article 124 clause 2, it provides every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges. So this is very important expression. After consultation with such of the judges of the Supreme Court and of the High Court in the state as the President may deem necessary for the purpose. So we need to understand that the appointment of the judges of the Supreme Court, if we go to the history, it is divided in 2 parts. Before 1993 and after 1993. Please understand, the entire game is in relation to maintain the independence of judiciary, which is the basic structure of the Constitution, which was laid down in so many judgments which we will be covering. So the ultimate object is to maintain the independence of judiciary and to eliminate the political and executive interferences in the appointment of the judges of the Supreme Court and also of the High Court. So if we talk about the before 1993 position, I will divide that in 2 parts. First is that the interference of the executive in relation to the appointment of Chief Justice of India, and the second part before 1993 position is that you will find the instances where the executive has been interfering in the appointment of the judges of the Supreme Court. First was in relation to the appointment of the Chief Justice of India, and second position is in relation to the interference in the appointment of the judges of the Supreme Court, also in relation to the transfer of the High Court judges, also in relation to the appointment of the High Court judges. So that's the second interference. Before 1993, first we will be covering the interference of the executive in relation to the appointment of Chief Justice of India. So please remember, the basic constitutional convention is that the senior most judge of the Supreme Court shall be appointed as a Chief Justice of India. When I say the senior most judge of the Supreme Court, how the seniority will be calculated? So please remember, the seniority is not calculated on the basis of the date of birth. Seniority is also not calculated on the basis that when that person got elevated in the High Court. So how seniority is calculated? Seniority is calculated when the person has come to Supreme Court and has been appointed as a judge of the Supreme Court of India. That date will be considered to determine the seniority of the Supreme Court judge. Now the question arises that what will happen if there are 2 or more than 2 judges who take the oath of the Supreme Court judge on the same day. Then in that time, the seniority will be decided on the basis of the fact that which judge took the oath first. That judge will be considered as a senior most judge on the Supreme Court of India. So as we are talking about the executive interference before 1993, the Law Commission in its 14th report in 1958 says that this convention that senior most judge should be the Chief Justice of India should be done away with, because in order to be the Chief Justice of India, apart from the seniority, there are other multiple factors which are required to be taken into account. So the government did not take this recommendation for a long period of time, but after the Keshwananda Bharati judgment, as you all know, Justice A.N. Ray, who was the fourth in seniority, became the Chief Justice of India, and the executive bypassed the three senior most judges of the Supreme Court of India. This created a lot of controversy, and here the government took the defense that they have adopted this 14th report which was given by the Law Commission in 1958. They have taken that recommendation, and that is the reason that they have appointed Justice A.N. Ray. They found Justice A.N. Ray more suitable to become the Chief Justice of India. So these three senior most judges who could not become the Chief Justice of India, they resigned in protest. And after that, one writ petition was filed in Delhi High Court, and the case name was P.L. Lakhanpal versus A.N. Ray, AIR 1975, Delhi High Court 66. So the appointment of Justice A.N. Ray as a CJI was challenged in three grounds. First, that it was malified. Second, that it was against the rule of seniority. And third, that mandatory consultative process under Article 124 Clause 2 was not resorted to. So the Delhi High Court said that as it is a writ of quo warranto, they cannot go in the motive of the appointing authority, that whether the act is malified or bona fide. And second, in relation to issue number 2 and 3, the Honorable High Court said that even if the judgment is being decided in favor of the petitioner, then also Justice A.N. Ray is going to be the Chief Justice of India, because the three senior most judges have already resigned from the post. So that writ petition became a kind of futile or infructuous exercise. Then second time, the problem in relation to executive interference in the appointment of Chief Justice of India was seen after ADM Jabalpur versus Shivkant Shukla, which came during emergency. So you may remember that so many writ petitions were filed during emergency, and so many high courts upheld Article 21, that Article 21 will not be suspended during emergency. So when those matters came to Supreme Court by way of appeal, because High Court granted the certificate under Article 134 capital A, Justice Khanna gave the dissenting opinion. It was a 5 judges bench, and the 4 judges said that even Article 21 can be suspended during emergency. But it was Justice Khanna who took the dissenting opinion and said that Article 21 cannot be suspended even during emergency period. You will be surprised that Justice Khanna, when he reserved his dissenting opinion, when he was talking to his sister, he said that I have written a judgment which will cost my chief justiceship, and actually it resulted in truth. You will be surprised to know that after 1976, Justice Beg was appointed as a Chief Justice of India, though it was the turn of Justice Khanna because he was the senior most judge of the Supreme Court. So again, Justice Khanna resigned from that post, though in 1978, amendment was taking place under Article 358 of the Constitution of India, relying on the dissenting opinion of Justice Khanna, which held that Article 20 and Article 21 both cannot be suspended during emergency. Coming back to the topic of convention, after Justice Beg, Justice Chandrachud, who was the second senior most judge of the Supreme Court of India, he became the Chief Justice of India, and from that day till today, this convention has not been breached. That is why I put this topic before 1993 topic, because after that, there has been no executive interference in relation to the appointment of Chief Justice of India. After that, an interesting judgment came in picture, which is known as S.P. Gupta versus Union of India, 1982 Supreme Court, though the citation cite it as 1982. The judgment was decided on 30th of December 1981. So why this judgment came, we have to understand bit background of it. There were so many judges who got transferred from one high court to another high court without even consulting with them, without assigning any reasons. And it was pointed out that this is an executive interference. Here there were various writ petitions which were filed in high court. I think almost 12 writ petitions which were filed in High Court, and the first petition was filed by Advocate Iqbal Chagla of the Bombay High Court. So it was a first writ petition. And S.P. Gupta, who was also an advocate in Allahabad High Court, he filed a fourth writ petition in the sequitur. In any case, all the matters got transferred to the Supreme Court, and when the matter came to Supreme Court decided few very important questions. And the first question was that, apart from the locus standi question, I'm not going into that. The first question was that who has the primacy in appointment and transfer of judges, whether the executive has the primacy of opinion or the executive has the primacy of opinion. And it was held that CJI opinion certainly has a great weight, but opinion of the CJI will not be binding on the president. And secondly, it was held that executive, which was the central government, has the final say in judicial appointment and transfer. So for example, if there is a conflicting of opinion, the CJI is saying, I'm of the opinion that this particular person should not be appointed as a judge of the Supreme Court or should not be appointed as a judge of the High Court. Whose opinion will prevail in that time? So this judgment said that the opinion of the Chief Justice will have the great weight, but if there's a conflicting of opinion, it is the executive opinion which will matter most. And secondly, it was held that consultation, the expression which is used under Article 124 clause 2, the consultation does not mean concurrence. After that, one important judgment we must note is the Subhash Sharma versus Union of India, AIR 1991, Supreme Court, page number 631. Though generally this judgment is missed, and immediately after SP Gupta we come to the second judge's case, which is Supreme Court Advocate on Record Association 1993. We'll come to that later, because Subhash Sharma versus Union of India was the first judgment which laid the emphasis on the primacy of the Chief Justice of India. And it also held that the expression consultation has to be interpreted in the context of the separation of powers. Though prior to this there was SP Gupta case, so it had to refer the matter to the larger bench. After this judgment, a writ petition was filed in the Supreme Court by the Advocate on Record Association versus Union of India 1993. It was the judgment, 9 judges bench judgment, and the judgment was delivered by Justice J.S. Verma. Few of the very important things which you must note down, that second judge's case overruled the SP Gupta case only to the extent of the expression that consultation does not mean concurrence. And this judgment, second judge's case, held that consultation means concurrence. And it also held that government does not enjoy the primacy or absolute discretion in appointment of Supreme Court judges. It also observed that why consultation was used in the Constitution. So it said that because the Chief Justice is best equipped to assess the worth of the candidate who is going to become the High Court judge or who is going to become the Supreme Court judge. He is the best person to know the worth of the candidate. So if Chief Justice of India says that the person should not be the High Court judge or the Supreme Court judge, it was held that it is the opinion of the Chief Justice of India which will matter. Also, we must note down that this expression consultation does not only mean the consultation with the Chief Justice of India, because it uses the expression that opinion of Chief Justice means the opinion of the Chief Justice formed collectively after taking into account the views of his senior colleagues. So the most important point which we take it from the second judge's case is this, that it is the primacy of the Chief Justice of India which will prevail, and the consultation means concurrence. As there were other guidelines which were laid down, but I'm not going to point out that, because in the third judge's case we will be covering the real guidelines which exist today. So after that we are coming to the third judge's case, which is In Re Presidential Reference 1998 volume 7 SCC page number 739. So again it upheld the second judge's case and it modified few of the important guidelines, and those modified guidelines I'm going to tell you. The first is that the expression consultation with the Chief Justice of India in Article 217 clause 1 and 222 clause 1 of the Constitution of India required consultation with the plurality of the judges in the formation of the opinion of Chief Justice of India. It means it is not only the opinion of the Chief Justice of India which will matter, it is the opinion of the Chief Justice of India with the 4 senior-most judges of the Supreme Court, which will be considered as a consultation. And that consultation is not only a consultation, but that consultation is a concurrence. The second point which was very important in this case was that whenever any judge is going to be appointed in the High Court or in the Supreme Court, it is the Chief Justice of India which must make a recommendation to appoint a judge and to transfer Chief Justice or the puisne judges of the High Court in consultation with the 4 senior-most judges of the Supreme Court. So whenever there is going to be any appointment in the Supreme Court or any appointment in the High Court or transfer of Chief Justice or transfer of any High Court judges, the recommendation will be given by the Chief Justice of India with the 4 senior-most judges of the Supreme Court. Now we are going to come in 2015 in the NJC verdict which is the National Judicial Appointment Commission verdict. Again, the case name was the Supreme Court Advocate on Record Association versus Union of India, and there were so many writ petitions which were filed and they were clubbed and all the writ petitions were heard together. So let's understand the background of that. 99th Constitutional Amendment was passed by Parliament. Here one more thing which we need to understand, that it was 121st Constitutional Amendment Bill. Many people get confused and they write 121st Constitutional Amendment Act. It was not the act, it was a bill which got converted into 99th Constitutional Amendment. So 99th Constitutional Amendment inserted Article 124 capital A to Article 124 capital C of the Constitution, which provided the National Judicial Appointment Commission, and the detailed procedure was given in the National Judicial Appointment Commission Act. So this National Judicial Appointment Commission consisted of these 6 members. I'm going to read that. First was the Chief Justice of India, who was the chairperson ex officio. After that, 2 senior most judges of the Supreme Court, who were also ex officio members of this particular commission. Third was Union Minister for Law and Justice ex officio, and 2 eminent persons to be nominated by the committee. Now, what was that committee? That committee consisted of the Prime Minister, Leader of Opposition, and Chief Justice of India. One thing which we need to remember, that the definition of eminent person was not provided neither in the 99th Constitutional Amendment Act nor in the NJC. So who are going to be the eminent person? It was quite a vague concept, because this composition can make any 2 persons as the eminent person. And here the primacy was not given to the CJI. That suppose if CJI says that no, this person cannot be an eminent person, there was no primacy. And the veto was given to any 2 members of the composition, because there was one rule which said that if out of the 6 members, 2 members says that the person is not going to be appointed as the judge of the Supreme Court or the High Court, then those persons will not be appointed as a judge of the Supreme Court or High Court. So here the primacy of the Chief Justice of India, which was the root reasoning which was given in 2nd judge's case and the 3rd judge's case, were actually taken away. So one of the very important question in NJC verdict was that whether primacy of the Chief Justice of India is the basic structure of the Constitution. Because what is the fight? The fight is that the independence of judiciary is the basic structure of the Constitution. So the question arises that whether independence of judiciary cannot be maintained without maintaining the primacy of the Chief Justice of India. So there were various and voluminous arguments which were taking place before the Supreme Court. But ultimately, Supreme Court in this particular judgment held that the primacy of the Chief Justice of India is paramount, and it is the basic structure of the Constitution of India. It means if you take away the primacy of the Chief Justice, you take away the independence of judiciary. This was the first reason that why this 99th Constitutional Amendment was struck down. Second point was that this eminent person concept was quite vague. Here, I remember the argument of a senior advocate, Arvind Datar sir, who put forth amazing argument, and he said that he brought out, I think, some 55 to 60 statutes all across the country. And he said that out of those 60 or 55 statutes, around 50 to 55 statutes defined the eminent person wherever this composition or any kind of composition is given. But this constitutional amendment, which is going to have a larger impact and which is going to appoint the Supreme Court judges and the High Court judges, this does not define the eminent person. So this argument actually hit the Supreme Court, and Supreme Court held that this eminent person is a vague concept, as it is not defined in the Constitution, and it has been left in the composition of or the discretion of the Prime Minister, the Leader of Opposition, and Chief Justice of India. And again, there the primacy has not been given to the Chief Justice of India. One more thing here, we need to remember that there was dissenting opinion which was given by Justice Chalmeshwar, who held that NJC is constitutional, and he held that this collegium system is vague. There is no clarity. Please remember that in his dissenting opinion, he was the judge who used the expression nepotism in the judiciary. So in any case, this judgment struck down 99th Constitutional Amendment Act. So again, we have come back to the position of 1999 third judge's case. So judges are going to be appointed as per the procedure which I just shown a few minutes before. So this is the procedure, and after that I will be covering the contempt proceeding and the court of record in my next video. Thank you so much.